Just hours before that unprecedented judicial referral, something else happened that shocked even veteran court watchers. Federal marshals physically removed Donald Trump's entire legal team from a federal courtroom in full view of cameras after the judge concluded they had committed perjury under oath. Not misconduct, not decorum violations, and not a procedural slap on the wrist. The court treated it as criminal conduct, and the response was immediate. If you are wondering why everything suddenly feels different tonight, this is why. Presidents have relied on time for decades. They litigate, appeal, delay, and let attention fade. They turn accountability into a calendar game. In that courtroom, the judge made a decision that collapsed the timelines that have protected powerful people for generations. Delay is gone. Stalling is gone. The clock is now judicial, not political, and that changes how every institution responds. Over the next 72 hours, Congress will be forced to move, alliances will fracture, and pressure will intensify on institutions that rarely face moments this stark. Stay with me, because what you are about to hear explains why impeachment is no longer a theory, why Washington is preparing for instability, and why the next 3 days may permanently redefine the presidency. And before we go any further, make sure you are subscribed, because this story is moving fast, and it is escalating by the hour. What happened inside that courtroom was not disorder. It was not chaos. It was control, and that distinction matters. When federal marshals move toward a defense table, that does not happen on impulse. It happens after warnings, after a record is built, and after a judge decides the line has been crossed. The court record showed the warnings, and it showed a pattern that the judge concluded could not be explained away. Under oath, Trump's attorneys repeatedly denied the existence of specific emails. They denied it again and again, not once or twice, but 17 separate times. They told the court those communications did not exist. They told the judge there was no record. They told the jury there was nothing to see. But the court already had material that contradicted those statements, and the contradiction was not subtle. The evidence included emails, metadata, and financial records that did not match the story being told at the defense table. When the judge confronted the defense, there was no clean correction and no clear retreat. The denials continued, and at that moment the trial did not merely pause, it changed direction. The judge ruled that the defense had crossed from aggressive advocacy into criminal conduct, and perjury is not a tactical mistake. It is a felony. So the order was given. Federal marshals approached the defense table. They instructed the attorneys to stand, and they escorted them out in full view of cameras, the jury, and the public. This was not symbolic. It was procedural enforcement, and it was the signal that the court believed it was dealing with more than a broken argument. It believed it was dealing with an attempt to interfere with the administration of justice. Here's where the story becomes more dangerous. Instead of simply appointing new counsel and continuing the trial, the judge stopped, assessed, and escalated. The court was no longer looking at perjury as an isolated act. It was looking at the possibility that perjury was connected to obstruction of justice tied directly to executive authority. When lawyers lie under oath to shield a client, the court has to determine whether it was directed, coordinated, or part of a broader effort to compromise judicial authority. Those questions cannot be ignored, and judges are trained to avoid politics at all costs. They do not step toward constitutional confrontation unless they believe the system itself is being tested. In that room, the judge concluded the threshold had been crossed. If you think this ends with lawyers being removed, you are missing what came next, because once a court determines that obstruction and perjury may be connected to executive power, the judiciary cannot simply look away. After the courtroom was cleared, the judge did not recess for the day. He did not merely delay for new counsel. He issued a formal judicial order, and the language in that order detonated in Washington. He wrote that obstruction of justice and perjury constitute impeachable high crimes and misdemeanors in connection with the conduct before the court. He was not speaking hypothetically or academically. He was describing what he believed the record now showed. Then came the line that sent shockwaves through the political system. The judge stated that congressional transmission was complete. That phrase is not rhetoric, it is procedure. It means the court assembled evidence, certified it, and transmitted it directly to the House of Representatives for impeachment proceedings. Not a memo and not a recommendation. The material itself. That package included full courtroom transcripts documenting 17 separate sworn denials. It included the emails the defense claimed did not exist. including a referenced payment communication tied to foreign-linked money that directly contradicted sworn testimony. It included body camera footage showing federal marshals escorting Trump's legal team out of the courtroom. It was time-stamped, cataloged, authenticated, and then delivered as a court-certified evidentiary record. It also included recordings that were never meant to be heard publicly. One captured Trump instructing associates to ignore court orders. Another captured threats directed at judges. These were not leaks, and they were not media scoops. They were exhibits, sealed and indexed, delivered directly to the House Judiciary Committee. The message was simple and brutal. This conduct cannot wait, and the court was not going to allow the normal slow-motion cycle to absorb it. Presidents have survived scandals by running out the clock. That option disappeared the moment a judge transmitted impeachment evidence mid-trial. Congress is no longer operating on political convenience. It is operating on a judicial clock, and once that clock starts, it does not pause for rallies, polling, or threats. If you are wondering why lawmakers suddenly look panicked, this is why, and if you are wondering why security is tightening, this is also why. Here is the part many people are only now beginning to understand. What happened in that courtroom did not create impeachment. It activated it, because Congress was already prepared. Long before the judge transmitted his evidence, a House impeachment resolution had been drafted and was sitting in place, dormant but complete. House Resolution 2353 contains 7 articles that were already legally structured for a moment like this. They alleged bribery tied to misconduct, abuse of power linked to misuse of executive authority, obstruction of justice, contempt of Congress, violation of the oath of office, and additional conduct tied to destabilizing uses of state power. For months, it sat without the votes to move. It had support, but not enough, and leadership knew that impeachment does not move on outrage. It moves on arithmetic. Everything changed when the judge's referral landed because it did not add allegations. It added evidence, certified by a federal court and assembled under oath. It removed plausible deniability, and it changed what lawmakers could safely defend. By the next morning, people who had been sitting on the fence were no longer debating politics. They were calculating exposure. Could they defend this on television? Could they explain it to voters? Could they justify silence when the record was no longer ambiguous? Names began to appear on the resolution quickly and not quietly. Republicans who had defended Trump days earlier began adding their signatures. Some issued statements. Some said nothing and simply signed. But the count climbed until it crossed a line that cannot be uncrossed. 220 co-sponsors, a majority of the House of Representatives. At that point, impeachment stopped being a threat. It became math. Leadership did not need to build momentum because the votes were already on paper, and when the numbers lock in, delay becomes dangerous. The party fracture moved from private discomfort into public defection because the imagery and the record had broken the last line of rhetorical defense. You cannot spin lawyers being physically escorted from a courtroom for perjury, and you cannot dismiss court-certified evidence as partisan theater. As this accelerated, the president reacted in the one way that made everything worse. He could not stop talking. Since the referral landed, Trump posted continuously on social media, and the tone was not measured. It was rage, accusations, conspiracies, and threats layered on top of threats. At first glance, it looked familiar because Trump has always lashed out under pressure, but this time every post became part of the record. Every message is time-stamped, archived, and preserved. When a president attacks judges while under active judicial review, it is no longer just rhetoric. It becomes potential intimidation and a piece of an obstruction narrative. When a president calls for resistance to Congress exercising constitutional authority, it is no longer just messaging. It becomes a signal that law enforcement and intelligence agencies treat as operational risk. Then came the post that set off alarms across Washington, a direct threat of civil war if Congress removed him. That sentence matters because agencies do not treat it like hyperbole. They treat it as a trigger risk. That is why security posture shifted overnight, why extremist communications were reportedly monitored more aggressively, and why contingency plans moved from dusty binders into active briefings. Washington stopped operating under normal conditions. National Guard units deployed across the Capitol. Barricades went up around key government buildings. Security perimeters expanded, and law enforcement presence became visible and layered, not because officials wanted spectacle, but because they were responding to the assumption that volatility could become physical. January 6th is not an abstract memory in Washington. It is operational knowledge, and officials know how fast online agitation can become action when authority figures encourage it. On the streets, two opposing crowds began to form in real time. Pro-Trump groups framed the moment as persecution and stolen power. Anti-Trump demonstrators demanded immediate removal and enforcement of the rule of law. This was not a normal protest environment. It was a pressure environment, and authorities treated it that way, aiming for deterrence rather than confrontation, while keeping rapid response units on standby. Inside the government, something equally serious unfolded. Multiple pathways to removal began moving at the same time. Impeachment was one lane, now active and accelerated on a judicial timeline. Once the House votes, the process triggers a Senate trial. It is not optional, and it does not depend on political mood. It forces evidence into the public domain under oath, and even if conviction is uncertain, exposure is guaranteed. Parallel to it, criminal investigations continued advancing. Evidence transmitted to Congress was also positioned to become evidence in prosecutorial hands. Perjury, obstruction of justice, and potential intimidation do not pause for impeachment, and courts do not wait for political outcomes. Grand juries do not stop because a president is angry. Then there was the option no one wanted to discuss but could no longer ignore, the 25th Amendment. Quiet conversations reportedly began taking place about capacity, not policy. That mechanism allows removal without a House vote or Senate trial if a president is deemed unable to discharge the duties of office. It can happen fast, and even the fact that it is being discussed tells you how severe the internal assessment has become. These pathways are not sequential, they are simultaneous, and that means Trump is boxed in from every direction. There is no single lever he can pull to stop all lanes at once. That is why the tone around Washington hardened. That is why patience evaporated. Officials understand that instability increases when consequences converge, and they are planning around the assumption that escalation will continue. Everything now compresses into a narrow window, 72 hours. That is how much time remains before the House is forced to act under an accelerated procedural mechanism designed for moments when leadership believes delay itself poses a danger to the country. Once activated, it removes discretion. It starts a clock that does not pause for negotiation or messaging. That is why the atmosphere feels different. Politics has been replaced by timing. Members are no longer debating whether impeachment is wise in abstract terms. They are preparing for a vote that is coming regardless of personal preference. The math is already on paper, and once that reality becomes public, behavior changes. Defections accelerate not because beliefs change overnight, but because delay increases personal and political risk. For Trump, time is no longer a shield. It is the weapon being used against him. Every social media post adds to the record. Every escalation tightens the case. Every attempt to intimidate hardens institutional resolve. There is no pause button, and the next 3 days are not just a countdown to a vote. They are a window in which additional evidence can surface, additional allies can defect, and additional exposure can emerge. When the House finally gavels in, it will not feel dramatic. It will feel inevitable because the outcome will already be locked by evidence, process, and time. People look for a single turning point, but collapses like this rarely happen in one moment. They happen procedurally. Once impeachment moves from theory to action, the presidency itself changes. Authority fractures, leverage disappears, and governance turns into friction. Even if the Senate ultimately falls short of conviction, the damage does not reverse. A president impeached under this volume of court-certified evidence does not regain control of Congress, does not regain trust from allies, and does not regain ease of movement inside government. Every executive action invites challenge. Every directive triggers resistance. Every appearance carries instability, and every new statement becomes another data point in a record that can be used against him. For decades, presidents survived by delaying and letting elections intervene. That era ended the moment the judge transmitted evidence mid-trial. The clock is no longer political, it is judicial, and judicial clocks do not care about rallies, messaging, or threats. What remains now is process, methodical and relentless, moving forward whether Trump cooperates or not. This is not the end of a story, it is the end of an illusion, the illusion that power outruns law, and the illusion that consequences can always be postponed. What happens next will determine more than one presidency. It will determine whether constitutional authority still carries gravity in the United States, and that decision is no longer in Trump's hands. It belongs to the process. If you want to follow what happens next as it unfolds, make sure you are subscribed, because once ambiguity disappears, events move quickly and history does not slow down to accommodate anyone.